I'm one of your co-chairs. Welcome again to the ANA Masters of Law. Please remember, if you want CLA credit, you need to sign in and sign out next to the registration tables upstairs. This session and the one that immediately follows it are a two-part series on consumer privacy. So we're going to start with the basics, and then we'll move to sort of more of an ad tech deep dive. So with no further ado, I'm going to let the panelists introduce themselves. Take it away, Kyle.
Hi, my name is Kyle Dull. I'm a senior associate at Squire Patton Boggs in our New York and Miami office. Prior to private practice, I was an assistant attorney general doing consumer protection work.
Hi, I'm Matt Libneski. I'm a commercial attorney. I work at Zynga. We were recently acquired by Take-Two Interactive Software, and pleasure to be here.
I'm Rick Borden, Frankfurt Kernet, cybersecurity, privacy lawyer. Spent most of my career in-house, so we'll have some interesting conversations.
Hi, everyone. Marisol Mork. I'm a litigation partner at Squire Patton Boggs in our Los Angeles office, where I maintain a broad consumer protection class action defense practice, and I also co-lead our firm's advertising, media, and brands interest group.
Okay, so quickly we're going to go through, this is our schedule, the new state privacy laws, California, Colorado, Connecticut, Virginia, and Utah. We're going to discuss cybersecurity risks, vendor data management, and then finally enforcement and litigation trends. And then throughout it, we're going to opine on what steps companies are taking to address these risks. Okay, just a general difference here between privacy and cybersecurity. Privacy is about protecting personal information, and cybersecurity is about safeguarding confidentiality, integrity, and information systems. A background on state privacy. Before we had the California law, our laws were based on the type of information and the industry sectors. And then now, coming next year, we have these different state laws. California was amended. We have Virginia, Colorado, Utah, and Connecticut. This is an updated map as of October of this year about the states that have passed laws, and in blue, there's pending legislation. Even in red states, we've had Utah pass a law. Florida has now attempted twice, so it is something on everyone's radar. Okay, and then talking about the state privacy laws, they regulate businesses and controllers. Personal information, the definition of personal information is much broader than you would think based on data breach laws, which are very narrowly tailored. Consumers are given different rights: access, correct, delete, opt out of sale. Again, the revisions to the laws, there's significant obligations on businesses with vendor contracting. I would say that there's stiff penalties, just judging by how California is going to evaluate what a violation is. These $2,500 and $7,500 can add up very quickly. Okay, so most states define their laws come into play based on certain thresholds. Sometimes it's a dollar amount, like California, 25 million global revenues. Other states are based on the number of consumers. Personal information generally is any information that can be reasonably linked to a person. There are some definitions that exclude publicly available information, and of course, de-identified or aggregate information. There are exemptions in all of the laws based on different federal laws and industries that are already regulated, but you need to be careful based on the Attorney General's published case summaries, where you're gonna see that there have been some healthcare companies and some insurance companies that have information that is not regulated by those industry-specific laws, and the California Attorney General alleged a violation, and those matters were settled. This might be a little hard to read, but this presentation is going to be available. You can see here there's a comparison between the rights provided under GDPR and the different states. And as you can see, they're not the same, which makes it very an interesting situation for businesses to comply with. And we're going to talk about that later, that that's going to be a decision. Do you want to treat everyone like they live in California? Or do you want to segregate each consumer based on the state that they live in and what rights you're going to give them? Coming January 1st, there are changes to the California law under the CPRA. HR data and business-to-business data comes into scope. This is going to be a significant change for businesses that don't traditionally have consumer data. And one thing you're going to have to do is you're going to have to offer rights to your employees. Let's see here. Okay. And then this was a hot topic a little bit ago. As of, you see the last bullet point here, September 1st, Nancy Pelosi, the Speaker of the House, issued a statement about whether privacy legislation would pass, and that legislation would have exempted all of these individual state laws. So right now, moral of the story is don't count on federal legislation passing, especially this year, because we're almost at the end.
Thanks, Kyle. So the next thing that we've got here is cybersecurity. And the takeaway that you should have is that cyber is actually regulated. So the information security organizations and the IT organizations are regulated in many states at this point, even though it doesn't exactly say that in the regulations. So we'll go through a variety of different areas that the regulation's coming up. So we're seeing things with like the SEC. The SEC has regulated through audit before. Banks are regulated through audit. They don't have these detailed regulations in the same way that the CCPA is there. But they're proposing it. So the SEC has proposed new rules for public companies, investment advisors, that have detailed regulations. And that's because that's happening in other parts of the industry. So, oh, whoops, should have had that slide up. Okay, sorry, so one thing that this group should really have in the back of their minds is the CFPB. So the CFPB, why, I'm talking about federal here, but the CFPB did something really extraordinary for the ad industry, really targeted advertising. So what they did was they actually did a rule interpretation. So this is not a rule that got put out for comment and is pending, and you're going to see new legislation or anything like that. The CFPB said, oh, well, if banks and other financial institutions that they regulate, if banks are using targeted advertising, using other companies to help them find and gain their customers and do things with customers, that's a core banking activity. So those entities are now regulated. And the banks have to have risk management programs for them. Now, we haven't seen where this goes next, but you're going to see a lot of activity coming out of them because CFPB is particularly aggressive. The FTC, and we'll be hearing about this in the enforcement side coming up. So it'll all tie together when we get over to enforcement with this. But what the FTC did was they actually grabbed something that we're going to have on the next slide, which is the New York Department of Financial Services cybersecurity regulation. And you're like, why do we care about that? Well, because what they did was they took the meat of the regulation, made a couple of changes to it, and moved it into the safeguards rule. And then what we're going to hear afterward is when they just went after Drizzly and when they went after IMED, they seem to have applied these same set of rules to those companies and fined them as a result. So we're getting a creep so NYDFS is the leader in cyber reg, and we're getting this creep in. So what you see is you have to have a risk assessment. You have to have policies and procedures, written policies and procedures on information security. Now, companies have this because they've got information security, but those now have to meet up to regulatory requirements, sometimes spoken or unspoken. But if you know where to look, you'll be able to find them. You have to have incident response. You have to monitor your service providers. We're going to be talking about that as well. And the state privacy laws are starting to incorporate this. They have these very general terms about cybersecurity, and everybody is looking at these regulations to see what it means. So here's the NYDFS. You can see it's a very detailed regulation, and they've been fining people. They've been finding people all over the place on cyber, not privacy. And all of the other regulators are going, hey, this seems like a good idea. So then we've also got Massachusetts. That's been out there for a long time. Not a ton of fines, but people definitely look to that. New York Shield, the Attorney General has been fining people based on New York Shield violations. Very general cybersecurity. Now, by the way, this is what captures everybody. If you have personal data of New York individuals that meets the test, your cyber is regulated. But the detail of the regulation doesn't match the enforcement. We'll talk about that a little bit. They seem to be taking this other stuff from DFS and saying, oh, we think that that's the right standard. And then if you're trying to understand your information security people, if you want to understand what they're saying and whether or not they've got a full program and whether it's useful, there's this thing called the Cybersecurity Framework. It comes from NIST. If you Google NIST Cybersecurity Framework, you'll find it. On page 22, you'll find, yes, this is how geeky it gets. On page 22, you'll find this chart. Page 23, you'll see where they start filling in the chart, and it'll tell you, oh, asset management, oh, you need to know what your assets are, and then it tells you other stuff to help you figure it out. But so you can use this as a guide. This is a guide for you to translate. Okay. So now we're on to vendor management.
Okay, so this is a new topic for here in the United States to consider, but a lot of businesses have been doing it already. What do you need to consider when you're forming your DPA with your vendors? I think, first of all, you're going to have controller-friendly agreements. You're going to have processor-friendly agreements. You would probably want to pick the one that applies to you and make sure it is friendly to your business environment. This is a very important one, and I'd probably want Matt to opine on it, is how do you make sure your marketing and sales people know what types of personal information are being considered? That's a big issue that we're facing with a lot of our clients, is that there's a disconnect between what's going on with sales and what's going on with legal when they're doing the DPAs.
Sure, I not going to comment specifically on my company, of course, but I think I've had some experience dealing with folks that maybe are programming a marketing campaign in a platform. They're not really understanding all the time what's happening under the hood So having an integrated process with the people that actually know what's in the payload when a bid request is sent. And as a lawyer, I didn't expect to have to know that either, but to know that someone doesn't know, I need to know, if that makes sense. Yeah, so it's evolved quite a bit. Dealing with procurement vendors, I would say we went from, I love the words US only, right? Now we progressed past that, and we're going to aim towards the most restrictive regime, California. And I'd look to you all, like, how would you characterize the next phase where you have this increasingly complex web of vendor requirements you have to push out, and they vary, and there's a lot of folks that are in businesses that are not in that sophisticated seat to characterize the data, map it, and communicate that to the legal team to write it appropriately. So, we heard that federal law is probably not going to happen anytime soon. Like, what are y'all telling clients? It's not a Socratic method. I'm actually asking.
So that goes back to our point originally. I think you need step one is teaching your sales and marketing team what personal information means, because they're going to default and think it's your name, it's your social security number. We're not collecting that. Well, you're collecting device ID, you're collecting IP address, cookie ID. That's personal information under all the laws. So step one is training there. The other step is what we've spent a significant amount of time on is crafting these really complex DPAs that incorporate all the state laws and all the requirements. And then again, if you have a company that is in the UK, in Europe, in Australia, that just adds another element to those agreements. And what you need to know is you need to work with your marketing team and your sales team to figure out where that information is actually going, so you know what you need to do. And I think that's step one and the most important thing to do.
Also, I just say that from a practical standpoint, when you're in a regulated industry, and unfortunately, you're now in a regulated industry, you may have conflicting requirements, or requirements that it's difficult to understand how to set up something that will follow all of it. So companies deal with that all the time by trying to get to that high water mark, and you may not get every element perfectly. Now, if you have things that say this must be in the agreement, and we'll talk about it on the next panel about specific language that needs to be, in there, but in some of these agreements. But you have to have a program that will show that you've considered these things and that you're making a good faith effort to get all of the compliance right, even though it may not use the exact wording from here and over. Like if you're under GDPR and you've got controller processor, okay, that's good for Virginia, but California, you've got business, service provider, third party. Which are you picking in your agreement to use as language? But then you just have to make sure you have all the specific elements. So it's complicated, but you have to pick something, go with it, and then look at it and try to cross it and track it.
Yeah, I'm sure that's important to track for enforcement. They're going to be asking for that information.
The contracts will come out.
Okay, generally, here are some of the obligations for vendor management. What do the laws require for controllers and businesses, and what about processors and service providers? Again, one thing here that Rick mentioned, there's audit requirements. That's going to be a key issue. These laws have certain requirements, and you're going to definitely put that in your DPA. Some of the laws require you to put that in there.
Are you finding people pushing back on that? I frequently will get vendors saying, well, I don't have to do that.
Yes.
Strike, and then
you reply and you cite the statute.
Yes.
Yep. So that's a difficult thing, is you're going to have vendors that are going to be like, no, I'm not going to do that. But it's a new requirement that's coming into place next year. So you can't negotiate your contracts December 31st, right? And it's going to be an ongoing process, especially for businesses now. You need to evaluate, where your contracts are and make sure you know what's going on.
And you may have to not work with certain vendors if they won't accept it now. That's one of the hardest parts of the job, right? Because when you're telling the business that they can't use a vendor because they're not agreeing to compliance, how do you deal with that?
Yeah, it's, hopefully you've built a lot of trust up until that moment to when you have to go to the person that owns the budget that's going to make that call. You're not being seen as going over their head. I mean, it's just kind of in-house 101 type maneuvering going on there. But yeah, I think, oftentimes if there's a red flag, I usually try to trust my gut. It's usually not wrong. Hey, this isn't a compliant company from our standards on paper, but it works really well. Like, that's not a combination that I want to hear.
Yeah, I usually tell them, if they don't understand this, then there are other problems. Exactly. We don't know what those are yet. But they have to, if they're in this industry, they have to understand this.
Exactly.
Yeah.
Oh, sorry. Don't get overwhelmed by that. It's for you to get overwhelmed, but after, here are the general requirements for the different state laws. Generally, they have you want to have restrictions on vendors, and there's certain requirements on there, like you want to require them to comply with personal information security purposes, and then you want to require them to either return and confirm that they returned and deleted the PI, or delete the PI at the end of the contract, or at your request. It's just all these things you need to consider in your contract to protect yourself from liability under the laws. And this is to do a little analysis here. So this is California. It has a lot of the same elements as GDPR, but the language is not the same, which makes it, as we mentioned, a fun situation for everyone to go through. Luckily, some of the states, here's GDPR requirements. Some of the states, like Virginia, Colorado, Utah, and Connecticut, they followed kind of the same rubric, and of course there were some negotiations somewhere when the laws got passed. As you see, Utah cut some requirements out, but the language is verbatim in some points, so that's good for businesses. Again, you have to consider what's going on with California because they have that $25 million threshold, so that's going to hit a lot of businesses. And then generally, aside from these fun state law requirements, there's some other things you really should consider, and maybe Matt, again, can opine on some of these.
Sure, yeah, I mean, I think, kind of I was speaking to earlier, the DPA negotiation landscape has changed a lot in the short amount of time I've been working on it, pretty hardcore way, to where, we went from a lot of people just signing it like they're at the DMV or they're at the rental car, like whatever, here, sign it, which is a bad sign. To where, now it's, give me your insurance certificate, what does it say, my additional insured, what does it cover, and, I'm finding more less sophisticated people in my mind are knowledgeable about specifically cyber insurance and being able to respond to those negotiation requests. Limitation and liability is probably the number one negotiated deal point, I would say, when it comes to these issues. And I'm curious, like, how you guys advise clients with measuring what that outside cap would be that's appropriate to make that determination. Is this liability cap or super cap or kind of tiered cap with an exception for fines or whatever, however you want to structure it? When you have a kind of a big question mark over the private cause of actions, and then the statutory damages. I kind of have my own thoughts, but I'm curious, like, how do you articulate that to clients that are saying, well, what should we agree to? What is this market?
Yeah, and you get into a lot of fights about market. I've had fights with lawyers about what's market, where they're telling me the things that aren't market, where I've negotiated about 100 of them, and it is. But in their minds, it's not. It's actually really interesting. What I do on limitation of liability a lot, and together with the indemnity, you have to put those together, is actually make it an insurance question. Like, okay, let's say, something does happen. You guys don't want to take the liability, or we don't want to take the liability. Whatever it is, it's like, who can buy insurance? So what will the insurance cost for this? And it becomes a pricing issue. So all of a sudden, it's actually a dollars and cents pricing issue, which the business understands. When you make it into an insurance discussion, you can then go and get a broker to price it, because you can price anything in insurance. You can go get a specialty, you can go to the London markets, and you can get a policy to just cover that contract for this issue. And so you'll know exactly what the price is on it. And vendors don't like this because now you're showing what the real cost of these things are. But that's one of the most effective negotiating techniques that I've found in these areas. Doesn't always work, depends upon who has the leverage, but it's eye-opening.
And so Matt, do you have any insight in negotiating these agreements with their low-value contracts? You're trying to get yourself covered. Any tactics there?
Yeah, I think it just comes down to the psychology of friction removing, right? So if you can, I don't want to say hide the term somewhere, but make them seem innocuous, so they're reviewed by a commercial party that is authorized, but you're not highlighting the fact that we're really worried about how you're going to respond to this liability cap provision or lack thereof if you're the vendor, which also is very surprising, as that people would still agree to that, and pretty rare these days. But yeah, I think just making it clear that this is a really important deal point up front and equipping the business people with that information going into the negotiation and having them fight before legal is extremely helpful. And we're not going to put in writing like what the bottom line is, but just getting them through a few negotiations and conversant about what is personal information versus how would you characterize this under the GDPR, et cetera. I found that very helpful to have the folks that are buying ads, for example, or buying a big service to be conversant before they even come to the legal department. That's been the most effective.
Great. Now, I think everyone's favorite topic will be enforcement and litigation because there's a dollar amount attached to it.
Otherwise known as Tales from the Crypt. No, I was thinking about that because, as you'll see, we've really had a couple of busy weeks around in October, so I think that is kind of fitting, actually. If there's any concerns here or questions, consumer privacy is a major enforcement priority, both at the state and federal regulatory level. We've been seeing litigation going through the courts now for several years. This is a hot topic, not just for litigation, but with very active regulators. This is a regulated area we're all in now. And there are lessons that abound based on if CCPA is what you're looking at, examples posted on the California AG's website, as well as the recent consent orders and settlements that we're seeing announced by state regulatory agencies and the FTC as well. So I thought a good place to start would be looking at state enforcements. California, with the passage of the CCPA, all eyes have kind of been on that state to see how enforcement would play out. Things started out, this is by way of background for what we're going to get into as a recent example, but things started out pretty playing nice in the sandbox, right? CCPA and the Attorney General's office issuing letters of alleged violations, detailing what those alleged violations were, and asking for companies to cure the alleged violations within the 30-day notice and cure provision. In June of last year, we saw an announcement from the Attorney General's office where they released several examples that were posted to their websites that were exemplary and examples that companies could look at to see what the alleged violations were at issue, and how those companies satisfactorily cured them to the AG's satisfaction. And we did not see any penalties being assessed. But now we have our first public enforcement, and we know that penalties have been assessed, and the Attorney General's office is also singing a very different tune than we saw in the last couple of, in the last year that we've been watching this. After quietly settling numerous enforcement actions to date, and I think they've been quite numerous in being permissive in the amount of time that companies were allowed to cure alleged violations, we see that the AG recently in August announced the settlement with Sephora. The violations there at issue were that Sephora had allegedly violated the CCPA because it failed to disclose to consumers in its privacy policy that it sells, within the meaning of the CCPA, their personal information, notwithstanding that its website had non-service provider cookies associated with it. And actually, the privacy policy at issue there affirmatively stated that Sephora did not sell personal information. There were also issues with the fact that do not sell my personal information links weren't easily available on the website or through the mobile app, and that the company also didn't offer its consumers at least two methods to opt out. The website also was not configured to detect or respond to the user-generated global privacy control opt-out. And after providing notice to Sephora, these violations weren't quickly or adequately addressed. And lo and behold, we find out that the AG's office has reached a $1.2 million civil penalty assessment against Sephora. What's really interesting about this case, and what the big note kind of takeaway is what it tells us about the AG's interpretation of what each sale is under the CCPA. Aside from the fact that there are real repercussions that now apply, we now have insights into the AG's very broad view of what is a sale. According to the California AG, if you have any online tracking technologies that you're using on your platform, like cookies, that automatically send data about consumers' online behavior to third parties, in exchange for free or discounted advertising services or the like, that constitutes a sale of personal information under the CCPA. I know, Kyle, you've blogged about this broadly. I don't know if there's anything else you'd like to add to that, but I think it's, like you said, given the numerous read of sale, this could get pretty pricey pretty quickly when we talk about penalties.
Yep, imagine all the website visitors that you have. It's just going to add up.
And what was interesting about the announcement in the press release here, there was a pretty clear message, no questions about it, language used by the AG's office, that the office is watching and keeping an eye out on you, and time's run out. You should be in compliance with the CCPA. And if this case is anything, they've got the arsenal to probably start with pretty high demands that are high enough to entice companies to want to settle and get rid of these cases at what would be a discounted settlement amount off of the high penalties that can be assessed for the various violations. Now to the iMed Vision Care case. We'll turn to New York. I know this case is near and dear to your heart. You've shared all types of insights with this. And as a California lawyer, this has been kind of a new area for me to walk into too and learn about. But iMed is in the business of insurance and providing vision benefits for those under its plan. It suffered a data security incident in, I think it was 2018. After that, DFS and the New York Attorney General both investigated to see what the deficiencies were, and found that some of the deficiencies included the company's alleged failure to conduct periodic risk assessments, and really, I think a key issue here that we've talked about was its failure to implement multi-factor authentication and secure access control over its employees' email accounts. But because it didn't have these controls in place, a third party was able to access the email accounts at issue within the company and access over 6 years' worth of consumers' data. And being in the health and insurance space, this was very sensitive data, including consumers' health and medical records. So earlier this year, the Attorney General settled with IMED for, I think it was $600,000, finding that the deficiencies at issue constituted violations of the New York State's Unfair Deceptive Acts and Practices, and also the SHIELD Act that we heard about earlier. Those same deficiencies were also found by DFS to constitute violations of the cybersecurity regulation, and that led to the settlement of $4.5 million in assessed civil penalties, in addition to other remedial measures.
Yeah, it was, I mean, this was a brutal one, because, and we'll talk about it a little bit more, the Attorney General seemed to grab the DFS requirements and use them, like directly, even though it's not in the SHIELD Act. And you see the same sets of things being cited, and it's very difficult for companies who don't know that those regulatory requirements are there. But everybody's following New York, and New York Department of Financial Services, like everybody, all the regulators out there are looking at the New York Department of Financial Services. So they're upping their game, they're proposing new changes to their regulation. They are becoming much more aggressive. We expect to see that bleeding itself out everywhere else.
And in fact, we kind of have, right, with Drizzly LLC. You mentioned this earlier, right? Just a few weeks ago, the FTC announced that it had taken action against Drizzly LLC, the alcohol delivery company app, and its chief executive officer, right, personally holding its CEO liable for alleged security failures that exposed the data of 2.5 million consumers. Now, what was interesting here, as someone that practices on the consumer protection side of things, is how the FTC used the deficiencies in statements made by Drizzly to hold that some of these practices were unfair and deceptive acts, as well as constituting false representations. Drizzly suffered a security incident in 2018. After suffering that incident, it publicly announced and made public statements that it had reasonably cured the deficiencies, identified what they were, taken steps to remedy them, which would presumably give users the comfort of this isn't going to happen again. But in fact, those deficiencies weren't adequately addressed, at least not in the eyes of the FTC and according to the allegations in the complaint. And Drizzly again suffered another data incident just 2 years later in 2020, which is the background for this FTC enforcement action. Among the violations at issue, and kind of just going back to the regs from New York, one of the issues was that Drizzly did not require employees to use two-factor, multi-factor authentication to access software and have adequate security measures in place, in addition to not having policies written up, not training employees on policies to protect the consumer data at issue here.
Yeah, and note the word adequate. It's not that they didn't have them, but they were found to not be adequate. And where did they, so, and I'm telling you, these things are straight out of DFS. The monitoring the network for security threats, the limiting access to customer data, the training employees, these things are all coming out of the same place. And this one didn't, there's a risk assessment piece of it that goes into all of it. So it seems to be that a new standard of care is being put in place. Now, there are ways to document all of this stuff, right? And to have compliance programs with policies and written policies and procedures that fill all those gaps, that look at that, using the cybersecurity framework. There's a way to do this. And companies that have been brutally beaten up by DFS have learned how to do that. But companies that are out there that don't realize that the FTC, the other part of the FTC that regulates financial institutions, well, they're the same people, and they're looking at the same things and going, well, if it's good enough over here, why isn't it good enough over there? Why wouldn't we expect the same? And that's what companies need to, that's what the takeaway is. You got to prepare for the regulators coming.
Especially now that we have kind of two cases, both at the state level and the federal level, that seem to be looking at the same deficiencies. Two multiple different regulatory schemes at issue, same underlying deficiencies that give hooks for these statutory violations, regulatory violations. And then again, just last week, we saw another announcement from the FTC announcing that it had taken action against Chegg Inc., a provider of educational services for lax security practices that resulted in actually 4 separate data breaches and misappropriation of its consumers' personal information. By the way, since it's in the business of educational services, the consumers were mainly high school and college students who had their sensitive information in these files, including stuff like their religious denominations, parents, income, levels of income, how they identify gender-wise. So this was very, very sensitive information that its own documents were seen to refer to it as being very highly sensitive information. Again, we saw the FTC alleging that Chegg had failed to implement reasonable security measures that are on your screen just in the interest of time. And this was another case where the FTC asserted violations of the FTC Section 5 for not only the unfair and deceptive practices and exposing the data of their consumers to potential hackers and identity thieves, but also as another example of the company representing that adequate security measures were in place when they in fact were not, thus giving rise to another violation under the false representation prong of the FTC Act.
And then one quick thing to look at there, there's some state law requirements there, right? You think about California, you're gonna have to set out a schedule that tells consumers what personal information you collect, why it collects the information. Those are state law requirements, but now the FTC is applying it.
So just a very high-level overview of litigation. It's not just the regulators that are enforcing this, but it's plaintiffs, right, in the courts that are looking to the courts to seek remedies for data incidents and cybersecurity events. The key issue that's litigated in the courts is whether or not defendants had reasonable security measures in place, right? That's the million-dollar question. And oftentimes that's an issue of fact that keeps a case going in the court system. We do not generally see violations of the underlying statutes or regulations as standalone claims, even though, yes, the CCPA does have a private right of action and provides for liquidated damages. We almost always see these claims accompanied by a variety of contract or tort-based theory claims, like negligence. And where I sit, I regularly see claims brought as unfair competition claims, similar to what the New York Attorney General did with UDAP in New York. We see those claims brought alleging underlying violations of the CCPA in California, for example. And then super quickly, for those of you who know of BIPA, Illinois regulation that governs how entities can collect and use and share biometric data, the big news that's coming out of there, we've got what the act does on your screen, is that last week we had our first BIPA class action that was tried to verdict. It took the jury less than an hour to find in favor of the plaintiff for a technical violation of BIPA. So if you're in Illinois, this act applies to you. We've seen an uptick already because of a ruling favorable to the plaintiffs on technical violations being enough to maintain a lawsuit. And now we've got a jury that quickly found in favor of a plaintiff. So expect to see an uptick in that litigation and to pay higher settlement values for what's already an inflated claim.
So this is going to be quick. I'm going to skip through some of these, and I'm going to go to the most important ones. Okay, one thing, California is going to require data retention schedules in your privacy policy. So one thing businesses need to look at is where do you keep your information and how long do you keep it? And that same piece of information might be in different areas, so it's going to be a very complicated procedure for businesses to undertake. We're at the end of the year, so it's, do your best effort, but get the ball rolling, document it, which is a key thing that we've been saying because that's going to go into your efforts to comply with the law. Here's some takeaways. I would say try to, again, data retention schedule, that's probably one of the most important ones, is figuring out where your data is and how long it's stored. Another key issue is if you're going to treat consumers all the same, no matter where they live in the United States, or if you're going to segregate them by state and give them different rights. And then again, record keeping is really important. And then, so another one is the consumer rights request. As I said, are you going to treat all the consumers the same? But you need to make sure that process is implemented correctly and it's accessing all the different areas where you store consumer information. Or if you're going to do it manually, make sure you have policies and procedures that are ample to accomplish that goal. We cover these topics on our blogs. So here are QR codes for Consumer Privacy World, which is Squire's blog, and Frankfurt's blog is advertisinglaw.fkks.com.
Thank you. Stay put for part 2.